Well, good morning, everybody. It's nice to see everybody. I'm Jeff Rosen, and I'm joined here today by Hugh Hurwitz, the Acting Director of the Bureau of Prisons, and with David Mulhausen from the National Institute of Justice, and from my own staff, Associate Deputy Attorney General Tony Bacon. All are key players in coordinating across the Department of Justice to implement the First Step Act, a truly monumental effort whose progress I'm pleased to report on today. The timely, efficient, and effective implementation of the First Step Act is a priority for the Department of Justice and this administration. The act is a bipartisan effort passed with strong support from President Trump and leaders in Congress, who all work together to pass and sign into law this important criminal justice reform measure. Using top-of-the-line research, people, and technology, the department intends to implement this law forcefully, fully, and on time with the goal of reducing crime, enhancing public safety, and strengthening the rule of law. The department's made significant strides in fully implementing the First Step Act. Today I'm announcing 3 major achievements related to full implementation of this important reform. First is the reduction of sentences and releases of inmates back into their communities. Since the passage of the First Step Act in December of 2018, approximately 1,691 inmates convicted of crack cocaine offenses have received sentence reductions as a result of retroactive resentencing under the Fair Sentencing Act of 2010. Additionally, nearly 250 inmates have been placed in the expanded compassionate release and home confinement programs. And starting today, at prisons around the country, nearly 3,100 inmates are being released from BOP custody due to the increase in good time credits applied to reduce their sentences under the First Step Act. So that's the first item I wanted to cover. Second, I'm pleased to announce that the Department of Justice has redirected $75 million in existing resources to fully fund the First Step Act in fiscal year 19. We will continue to work with Congress and the administration to ensure additional First Step funding is appropriated for fiscal year 2020 and future years. In this regard, I want to underscore the Attorney General and I both recently toured federal prisons, and we saw firsthand the tremendous value in quality programs for inmates. The Attorney General has directed additional funding for inmate programs for FY19, including resources to expand vocational training and job readiness programs, to increase the availability of medication-assisted treatment, to support programs tailored to the needs of the female inmate population, and to increase education opportunities for inmates. Now, third, as called for by the First Step Act, we are today announcing a new risk and needs assessment system designed to assess inmates' risks of recidivism and to identify their individualized needs to reduce the risks of their reoffending when their terms are up. Through this system, inmates will have the opportunity to receive earned time credits in addition to good time credit and to participate in evidence-based recidivism reduction programs. As the Bureau of Prisons developed this assessment system, the department and the folks I'm with here today, among others, listened to experts and a wide variety of stakeholders, including our law enforcement partners, the U.S. Pretrial Services and Probation Office, the National Institute of Corrections, think tanks, nonprofits, legal aid groups, and others. But I want to single out for thanks one in particular, because we are especially grateful for the Independent Review Committee of 6 nationally prominent experts, which has worked incredibly hard to help the Bureau of Prisons to this point, and they continue to provide invaluable expertise and analysis to this process. So the new system, which is called, in a catchy phrase, Prisoner Assessment Tool Targeting Estimated Risk and Needs, or more simply as an acronym, PATTERN, will be used to screen all federal inmates to identify risk factors and identify evidence-based programs that are likely to reduce the risk of recidivism and meet individual needs such as drug treatment, job training, trauma treatment, counseling, and education. The new tool relies on predictive assessments using both static and dynamic factors, dynamic meaning things that can be affected by the individual's changes in the individual's situation, to gauge the risk of every inmate in our federal prisons. The pattern assessment achieves a higher level of predictability and surpasses common risk assessment tools currently used for correctional populations in the United States. Now, while we believe this tool to predict recidivism is an improvement over the existing system, we also recognize that there is room for additional change as we continue through the implementation process and gather more data. So we are encouraging experts, practitioners, advocates, academics, and others to comment on the report that's released today so that we can build the best and most fair tool that is possible. And in that regard, we have scheduled several listening sessions in September after a period to receive comments. So before I conclude my remarks here today, I want to just take a moment to thank the team that made it happen, because tomorrow was a statutory deadline, so it was no small endeavor to get this done. I want to thank in particular the Justice Department's Bureau of Prisons, the National Institute of Justice, the Office of Legal Policy, the Executive Office for U.S. Attorneys, the Criminal Division's Office of Policy and Legislation, all of which played critical roles in meeting the tight timelines imposed by Congress and in carrying out the mandates of the First Step Act. And in particular, in meeting these timelines, I want to note the department has already made substantial progress by implementing new and expanded programs that address issues such as drug addiction, job skills training, and networking with private sector employers. Already, the Bureau of Prisons has developed a dyslexia screening process, a youth mentoring program, and has updated its procedures for managing pregnant inmates. The Bureau of Prisons has already trained 31,000 employees and officers in de-escalation techniques and mental health awareness. So I want to give special thanks to Hugh and his team for their commitment and dedication to this project. And I'd like to just make clear that Attorney General Barr has made it clear that reducing crime and violence in America's cities and rural areas continues to be a top priority of the Justice Department. And this first step will help to achieve that end and ultimately increase the safety of our nation's communities by helping improve the lives of the inmates and reducing recidivism when their terms in the prisons end. So the Attorney General's commitment includes strong support for federal, state, local, and tribal law enforcement, as well as a continued aggressive approach to prosecuting federal crimes. Finally, let me just say that today's announcement is only the first step of a longer journey towards the comprehensive implementation of the First Step Act, which the department, as I've said, will continue to pursue vigorously. And with that, I will turn over the podium to Hugh Hurwitz, the head of our prison system, to talk more about how the Bureau of Prisons is prepared to implement the First Step Act.
Thank you, Deputy Attorney General Rosen. Good morning. It's an honor to be here to mark this critical moment in the implementation of the First Step Act. I'd like to first thank the Attorney General and the Deputy Attorney General for their leadership and commitment to this effort and for their support of the Bureau of Prisons as we work together to achieve our mission of helping offenders transition successfully back to the community and maximize public safety. I also want to thank the staff of the Bureau of Prisons for what they have accomplished thus far and will continue to achieve as we look forward to implementing the next phase of the First Step Act. The philosophy of the Bureau of Prisons is that release preparation begins on the first day of incarceration. By offering a variety of programs and activities, the Bureau helps inmates enhance their skills to support a successful reentry back to the community. These programs seek to improve reentry outcomes by targeting behaviors that increase the risk of recidivism and promote pro-social behaviors. The First Step Act allows us to further enhance our programming and focus resources on higher risk offenders. The new risk needs assessment system identifies numerous factors related to the federal inmate population which are key to identifying recidivism risk. Use of the assessment will enable staff to better predict risk and assign programs designed to mitigate or eliminate that risk. It will allow us to measure the effectiveness of how we're doing and improve and refine the performance of the tool and our processes over time. As I mentioned earlier, the Bureau of Prisons offers programs which address specific criminogenic needs of each inmate, programs such as drug treatment, education, and job skills. Under the First Step Act, the Bureau of Prisons can more thoroughly target and address individualized inmate needs and monitor the inmate's progress in addressing those needs. We recognize that not every inmate is in need of intensive programming. We will ensure, however, that those inmates with fewer or no needs maintain their low risk by assigning them to productive activities which reduce inmate idleness and provide opportunities to gain new knowledge or skills. The Bureau's largest work program is Federal Prison Industries, also known as UNICOR. Inmates participating in UNICOR learn real-world job skills and gain work experience in such areas as clothing and textiles, furniture, electronics, recycling, vehicle reconditioning, and services such as call centers, data entry, and distribution. With regard to education, all of the Bureau's institutions offer programs that include literacy classes, English as a second language, parenting classes, wellness education, and adult continuing education. Inmates are also able to participate in post-secondary classes in partnership with local community colleges or universities. The Bureau also provides inmates with career technical education and apprenticeships in a variety of fields, including building trades, mechanics, horticulture, food preparation, and cosmetology, as well as job readiness certifications in areas such as CDL licensed drivers and biomedical technicians. The First Step Act provides us with the opportunity to add new programs and enhance and expand these existing programs to help reduce risk, reduce recidivism, and better prepare inmates to return to our communities. It's also important to note that the First Step Act involves more than just risk and needs assessment, and the Bureau of Prisons is focused on ensuring all the provisions of the law are carried out. As the Deputy Attorney General noted, the Bureau of Prisons has already implemented a significant number of these or other requirements of the law. We've updated our policies on compassionate release. We've updated training on the prohibitions against shackling pregnant offenders, a practice that we've prohibited since 2014. We've screened inmates and offered medicated assisted treatment to eligible inmates due to release in the next 18 months. We've issued policies regarding the storage of personal weapons by staff, a provision of the law that was in honor of a fallen BOP staff member, Lieutenant Osvaldo Albarati. We ensured that sanitary products are readily accessible for female inmates, and we confirmed that BOP contracts for the confinement of juveniles is consistent with the Act in regard to prohibiting room confinement. BOP institutions also offer job readiness classes, including resume writing and interviewing skills, and they host mock job fairs to prepare inmates for the transition back to the community. In preparation for the inmate releases today and in the future, we announced a Ready to Work initiative to partner employers willing to offer job opportunities to inmates seeking employment. Many staff worked long hours to help get us to here today. We have a lot to be proud of, but we still have a lot more to do. I look forward to the continued collaboration between the Bureau of Prison staff from across the Department of Justice, and the many stakeholders with an interest in helping to reduce recidivism. The First Step Act will improve the federal criminal justice system and help make our communities safer. Thank you to the Department of Justice and the thousands of dedicated staff of the Bureau of Prisons for their commitment and support of this important new legislation and to the mission of the Bureau of Prisons. Now I'd like to introduce David Mullhausen, Director of the National Institute of Justice.
Thank you, Hugh. I appreciate Hugh's leadership and the BOP's dedication in implementing the First Step Act. I am David Mullhausen, the Director of the National Institute of Justice, and it's a pleasure to speak to you today about NIJ's important role in implementing the First Step Act. NIJ was honored to be given the opportunity to play a role in implementing this historic criminal justice reform. Importantly, as the research, development, and evaluation agency of the department, it was exciting for me and my staff to have the chance to infuse science into this important work. Developing the tool was no small task. Though we had very little time to get the job done, we did our very best. Today is a great example of the patience, collaboration, and hard work it took to get us here. As part of our role in the Act, NIJ contracted with external experts, Drs. Grant Dewey and Zachary Hamilton, to develop Pattern. As mentioned by Deputy Attorney General Rosen, Pattern is a significant advancement in the department's implementation of the First Step Act. To develop Pattern, we did not work in a bubble. We reviewed existing risk and needs assessment systems, we brought in outside experts and researchers, and we sought the advice of the Independent Review Committee. And importantly, we worked closely with our colleagues at the BOP to learn more about their systems and how we could work together to improve upon their current practices. We also held listening sessions with a range of criminal justice stakeholders, including prison reform advocates, law enforcement groups, victims advocates, and many others to hear their perspectives about the development and implementation of a risk and needs assessment system. I want to take the opportunity to thank all who participated in these listening sessions. I am particularly proud of the tool developed by Drs. Dewey and Hamilton. Pattern is a vital step in implementing the First Step Act, but we have lots of work ahead of us. We look forward to working with our colleagues, our experts, and interested stakeholders to continue this essential work. We will continue to collaborate with the BOP. NIJ is committed to rigorously evaluating BOP programs, ensuring that these programs are evidence-based. We need to learn more about what's working to reduce recidivism among BOP inmates. With this information, we can assist in the development of innovative, evidence-based programs to help ensure that when inmates leave the BOP, they have the skills they need to lead law-abiding lives. It's clear we have a long road ahead of us, but we are excited to take the next step. As I close, I want to offer my sincere thanks to NIJ staff for their hard work over the last few months, and especially the last few weeks. Your hard work and patience has not gone unnoticed, and I am extremely proud and appreciative of you all. I want to thank Grant Dewey and Zachary Hamilton. Your vision and commitment to developing Pattern in support of the department's goals was paramount to our success. As our work continues, we are committed to working with our federal partners to implement the First Step Act. We will continue to improve Pattern into a tool that will serve the BOP and hopefully all of society for years to come. Thank you.
You say 3,100 inmates are released today from BOP custody. What kind of custody? Were these people in prisons, in halfway houses? Where were they?
Well, I think the short answer is in prisons, but to give you a little more specificity, I'm going to invite my colleagues to address that.
Most of the inmates releasing.
Want to step up? Thank you.
Most of the inmates, all of the 3,100 inmates are releasing from Bureau of Prisons custody, whether they're in a halfway house or one of our federal facilities, they're in our custody. So they're all releasing from Bureau of Prisons custody. So when you look at tomorrow's population numbers, we'll be 3,000 inmates fewer than we had today. Most of them releasing out of RRCs, actually, and there's about 900 that have detainers that'll be releasing from our custody, but I can't tell you where they'll go because that's up to states or Homeland Security. But of the ones that are releasing to the community, almost all of them are releasing from RRCs.
Yes, on the on Pattern, is that to determine eligibility for early release, or just what sort of work has to be done before they're released?
Tony, you want to answer that?
So the pattern tool will do a couple of different things. First, it will assess every single inmate's individual risk of recidivism. From there, the inmates will be put into a category of either minimum, low, medium, or high. Those in the minimum or low categories will qualify to earn what's called earned time credit for successful completion of evidence-based programs. The First Step Act reads that those in the medium and high categories have the first priority to participate in the programming, although BOP is committed to offering programming across the groups. So pattern will be used to assess everyone's risk score, and then every 6 months they will be reassessed and have the opportunity to lower their score, and that's what we're excited about, to lower into the lower categories, to maximize the earned time credits, and eventually lower recidivism rates.
Two quick questions. First question is, can you give us a sense of the range of offenses, types of offenses that the 3,100 who will be released, what they faced, and what's their reaction to this new opportunity?
Yes, in terms of the range of people who have been released, the largest number are drug offenders. The second group are weapons and explosives, and the third are sex offenders. But there's a very wide range of people who are being released. There are actually some national security, some robbery, offenses against the court. So it's a broad spectrum of the BOP population.
Yeah, and on a separate matter, yesterday we received confirmation that the Southern District's investigation of Michael Cohen and his campaign violations, finance violations, is complete. I'm hoping you can provide some clarity to one aspect of the case. The government sentencing memorandum claimed that Cohen committed 2 campaign finance felonies, quote, in coordination with and at the direction of individual one identified as the president. With the case now being, or with the investigation now being closed, does that mean that individual one, the president, was cleared of any wrongdoing?
So I'm going to say 2 things about yesterday's news on that. Is there was a FOIA, Freedom of Information Act case, in which the judge in the Southern District of New York required the department to disclose the state of play, which included, therefore, the item you're referencing as to the department having effectively concluded the matter. So that document is a public document, but in terms of what it addresses and what it covers, really the only thing I can say about that is that it was handled by experienced prosecutors who looked at the law and the facts and made their conclusions on the merits.
Deputy Attorney General, can you say whether you or the department, Main Justice, played a role in that final conclusion? And then secondly, can you say whether the OLC memo that the president cannot be indicted played a role in this as well?
I don't have anything to add to what I just said.
The 3,100 people being released, is that happening like today or over the next many weeks? And where are they being released from? All over the country or what?
You want to take that one?
So all 3,100 will be released today, and there's a process. Bureau of Prisons releases inmates every day, and we're following our normal processes in doing that, and it'll happen throughout the day. And the second half of where, they're all over the country. They're either at institutions or halfway houses across the country.
Yeah, on the Attorney General had said that we should expect the IG report on the FISA process in May or June. We're now in mid-July. Is there any update on that?
Sorry, I don't have anything to share on that today. Nothing to add beyond what's already been said.
Claire, some of the classes or programs available to inmates reportedly have waiting lists. What is the department doing to ensure that all inmates have the opportunity to earn credits?
Yeah, some of our programs do have waiting lists. Programs like Unicore that I mentioned in my remarks, which is one of our largest programs, but is restricted by the amount of work that Unicore has. They're not funded by appropriations, and so they have to have business in order to have work to do. Most of the types of programs we're talking about do not have waiting lists. There's most of our vocational training programs, our education programs, and psychology programs our inmates are able to get into now, but that's part of the money that the Attorney General mentioned, the Deputy Attorney General mentioned, that we're going to be increasing our programming so we have enough programs to make sure everybody can participate in programs that they need.
Can I just embellish one thing about that, and feel free to chime in. One of the important ones is the residential drug assistant treatment, and there is no wait list for that one, and that's an important priority for the Bureau.
Yeah. So has the Department of Justice come to an agreement with Congress regarding whether or not members of Mueller's team will be testifying? And has the department provided any resources to Special Counsel Mueller ahead of next week's testimony?
So with regard to the Special Counsel Mueller's testimony, I think it's a matter of public record that the Attorney General had said that he would leave that to Director Mueller, that he did not have an objection. Special Counsel Mueller held a news conference some weeks back where he indicated his report was his testimony. So I think it would be reasonable to assume or expect that he meant what he said, but we'll see.
Can you explain the difference between the risk and needs assessment tool being released today and the tool already in place by the Bureau of Prisons, the security assessment tool?
You want to take that?
I'll kind of try and cover it very simply. It's our security assessment tool, as you mentioned, focuses on predicting misconduct in our institutions. This tool takes that and expands on it to add additional criteria so that it's more likely to predict recidivism instead of just misconduct. We think our tool for predicting misconduct does a very good job doing that, and so we're able to hopefully, with this new tool, take that a step further.
One primary difference between the old tool and the new tool is that we really took feedback from the listening sessions and stakeholders and the Independent Review Committee and added dynamic factors, more dynamic factors. This is important because this is what gives inmates the opportunity and the incentive and the encouragement to take advantage of these programs and want to change. And it will allow every 6 months, as the BOP reassesses, for inmates to successfully complete a program and watch their score go down, which will lead them to want to take more programs, lower their security level, and overall increase public safety. So this tool, it was very important in developing it to make sure that we had sufficient dynamic factors to really encourage folks to take advantage of that.
I wanted to ask about the medication-assisted treatment programs. So my understanding is that currently the Bureau of Prisons does not offer all 3 treatments throughout the duration of a person's stay, even though scientific evidence suggests that that is useful for people suffering from opioid addiction. And recently the Bureau of Prisons settled a lawsuit that the ACLU brought on behalf of an inmate who needed access to methadone throughout the duration of her time at BOP. Why isn't the Justice Department offering all 3 treatments to inmates? Will you use some of this money to do that, especially given the fact that the DOJ in some U.S. attorneys' offices has pressured state prisons to do the same thing?
And that's exactly what we're working toward doing, is right now, you're right, we offer one type of treatment. It's a reentry program. And now we're looking at expanding that and working to expand that, and we're going to be using the resources, hopefully, that we get from the First Step Act to do just that, to expand that program into more of throughout your entire incarceration, using other forms of drugs to do that. Those decisions haven't been made yet, but I expect that certainly we'll be doing more than we are now. So.
If I could ask too, you mentioned you're redirecting $75 million. Where is that money coming from? In other words, like what priorities are losing money so that you can work on it?
You want to take that one? Or is that better for you, David?
Yes, I believe that came from excess money from the U.S. Marshal Service. We can verify and double check that, but my understanding is that was money the Marshal Service was not going to be able to use by the end of the fiscal year, and that BOP is ready to use now to expand these programs, to expand the opportunities for medication-assisted treatment, and to begin work on the needs assessment system, building that out.
And let me just embellish slightly on that, in that where we are in the fiscal year, which ends September 30, means that we're roughly a quarter and a half. So that's a pretty significant amount of money, rather than have it not be used optimally. Attorney General made the decision to use it in this way, and in the amount of time that's available, it's a pretty substantial amount of money.
And then a sort of second question. The Office of Professional Responsibility has said that they're investigating the handling of Jeffrey Epstein's plea back in 2008. Will you commit to making the results of that investigation public?
You're accurate that that's underway, but with regard to specifics, there's really nothing I want to get into on that today, and so I'm going to save that one for another day.
So you won't commit right now to making the results of that investigation public?
Well, I'm saying I don't have anything I want to share on that today.
Yeah, you mentioned earlier there were more than 1,000 retroactive crack releases in this group that's been released recently. Is there a concern that they pose a greater risk of reoffense because they weren't able to take advantage of the programming that you're announcing today? And I had another separate question.
So your observation is correct that those whose sentences were recalculated right at the outset were just recalculations under the Fair Sentencing Act of 2010. And so that's accurate. In terms of the individual population, you always have to look at the specifics of who those were, and that's a little bit why we do individual assessments in the risk assessment and the needs assessment. And so as I stand here today, I'll see if my colleagues do, but I don't think we have a good breakdown of what programs that somebody has, but I don't have, what that population looks like in terms of the recidivism risk. But we are always interested in that question, because one of the goals of the First Step Act is to reduce recidivism, and we would like for it to be zero, but unfortunately, that's not always the way it works out.
Can I ask just to follow up? What weight, I just wanted to follow up on Evan's question earlier about the weight that was placed on the OLC memo that advises against or prohibits the prosecution of a sitting president. What weight was placed on that in deciding to close the SDNY investigation?
So I'll just refer back to what I said earlier. I don't have anything to add to that. We had experienced prosecutors who looked at the law and the facts and rendered the conclusions that they have.
Your last question, Sadie? I was hoping I have two as well, but I was hoping first you could talk a little bit about how the members of the review committee were chosen.
So under the statute, there was a process by which first a host organization was selected, and then they helped organize the identification of candidates and the recruitment and selection of those. So that's the statutory aspect. In terms of how it was actually done, maybe I'll let David take that one.
The independent review committee is independent, and the host organization had its own authority to pick committee members. And so I believe they picked a very good set of individuals who have provided very good information to us to get us to this point today.
Can I just augment that to say, it was by design, people of varied backgrounds, experiences. There's a couple of academics, there's someone who's run a prison system, somebody who's had a drug abuse background. So by design, there were people of both varied experiences, varied professional settings, and a diversity of viewpoints. And we've been very appreciative to have them assist and participate.
And then I just was wondering, the Justice Department has several cases involving clients of your old firm, Kirkland. I was wondering if you intend to recuse from any of those cases, such as the case involving Goldman, 1MDB, and Boeing, if you can give us some insight into that.
I'll answer that. The way the federal ethics rules work is ordinarily when you depart from a law firm, there's recusals of anything within the first year under President Trump's executive order, the period was extended to 2 years. So anything involving Kirkland and Ellis for a period of 2 years would have been a recusal, but I am outside of that window. I am more than 2 years removed from Kirkland and Ellis, so I do not have any automatic recusals for matters that involve Kirkland and Ellis. There can be unique situations if it was a matter I personally was working on, so I'm slightly oversimplifying the landscape, but in general, I do not have recusals based on having been at Kirkland and Ellis more than 2 years ago.
Thank you. Thank you very much.
Thanks, everybody.
Any reaction to the AG being held in contempt?
Want to take that one, actually?
I do have some thoughts about that. Three of them. First, just looking at the underlying dispute and how the House of Representatives gets to the situation that they did is that the Justice Department and the Commerce Department had provided thousands of pages of documents, and the documents that were in dispute included documents that had been deemed privileged and confidential by a federal court. And we're talking about a matter, the census, in which the Supreme Court has already ruled, and we have moved on. So the House has not identified some compelling legislative need for this. To the contrary, this makes no sense at all. Second, we are talking about, given the absence of an appropriate basis for this, we are talking about what is, unfortunately, the crassest form of political theater. And from where I stand, I'm deeply disappointed that the House leadership would proceed in that way with something that is so obviously beneath the dignity of the offices they hold. It's really a new low for the current House of Representatives. And I guess the third thing I would say is it's not too late to reverse course. The House of Representatives could reconsider, revoke its action, and apologize to the Attorney General. And that's what they should do.
Thank you. Thanks, everyone.
Or you could hand over documents, right?
Did you hear what I said?